Hi, and welcome back to another video. For those of you who are new here, my name is Peter Lamont. I'm a New Jersey attorney, and I make videos like this to help explain some of the very complicated and confusing aspects of our legal system. And in today's video, we're going to be looking at non-disclosure agreements. And this is really important, I think, to everyone, because at some point in your life, you're likely going to encounter a non-disclosure agreement. You could be an employee, you could be an employer, CEO, independent contractor, whatever you are. Chances are at some point you are going to be handed or be handing someone a non-disclosure agreement, and it's really important that you understand what the heck it is. Now, we are going to specifically look today at the difference between a non-disclosure agreement and a non-compete agreement. Now, these are often mistakenly used interchangeably, and I hear it all the time from people inquiring about what a non-disclosure is. They often use both terms. They say, well, I've got a non-disclosure, non-compete, non-disclosure. It's the same thing, right? It's absolutely not the same thing, and we're going to explain the differences today so that you have a better understanding of what a non-disclosure agreement is compared to a non-compete. All right, let's jump right in. So first of all, when you sign an agreement that restricts your ability to do something, whether it is to disclose information or with respect to a non-compete, to compete with your current or former employer, you are signing a restrictive covenant. This is a fancy legal term for documents like non-disclosure agreements, non-competes. A restrictive covenant. What does that mean? Well, you're promising to restrict your behavior to a particular set of parameters. Okay, so for example, in a non-compete, you are promising to restrict competing with your employer or former employer for a given period of time. And in a non-disclosure, you are promising not to disclose certain information. So these documents are generally referred to as restrictive covenants. Now, there are a number of restrictive covenants. A non-disclosure agreement, an NDA, which is the acronym you've probably heard most often, is a form of a restrictive covenant, as I just said, and so is a non-compete. But they are not the same thing. So let's first look at what a non-disclosure agreement is. A non-disclosure agreement is an agreement that you enter into whereby you promise not to disclose certain information of that current employer, or if you're an independent contractor, the company or person that's hired you. What kind of information are you promising not to give out or talk about? Well, that really depends on the agreement itself. Non-disclosure agreements are, like all restrictive covenants, very specific. It tells you in the contract that you're signing what it is that you are promising not to do. So you might have a non-disclosure agreement that says, hey, you're going to be working with my company, and we're going to be selling widgets, and these widgets have special proprietary information about them. And I don't want you, as a salesperson, to divulge my trade secrets. I don't want you to go and tell a competitor, hey, this is how, Frankie makes the widgets. And that would be detrimental. So you can understand why that company would not want the trade secrets about those widgets to be disclosed to another company or a competitor. So in that example, that non-disclosure agreement, you might be agreeing not to disclose trade secrets or protected information. Another example might be if you are, let's say an independent contractor being brought in to do some bookkeeping work. And that company doesn't want you to disclose any of their financial information. So they might have you sign a non-disclosure agreement preventing you from talking about their finances to another company. So the idea behind a non-disclosure, as you've probably figured out already, is that the company or individual who is giving you that non-disclosure agreement wants to protect It's valuable information. What is valuable to that company or individual is up to them. It could be finances. It could be trade secrets. It could be marketing information. It could be client lists. It could be the way that they do a particular thing. Let's say you make candy. Maybe they have a proprietary method of making their saltwater taffy, and they don't want other people to know about it. What about Bush's Baked Beans, where they've got that secret baked bean recipe in a book? Actually, look it up online. They actually have a museum out in Tennessee, outside of Gatlinburg. And in the museum, I don't know if the actual recipe is in there, but they have the secret book. But you've heard about secret recipes, and I think Jack Daniel's has proprietary. Everybody does, right? Everybody. But you've heard about it from some of those larger, food and beverage manufacturers about their secret recipe, or their secret sauce, and that sort of thing. Those are considered trade secrets. So if you work for Bush's Baked Beans, you probably have to sign a non-disclosure agreement if you have access to the formula. And that's really at the heart of what a non-disclosure agreement is. The point is to protect secret information that makes the company or individual's products, services, processes, client lists, all that stuff secret. You have access to it and you need it as an independent contractor or as an employee, but the company doesn't want you going and selling it to other people, talking to other people about it. They don't want other companies who might be their competitors to have that information. That is what a non-disclosure agreement is. Now, what is the difference between that and a non-compete? Well, it's actually a monumental difference. A non-compete is when a company asks or requires you not to compete with that company in the future. Now, how does it usually look on paper? Well, it's usually something that says you agree not to work. Let's say you work for a hair salon. You agree not to work for another hair salon within a 5-mile radius of the company that you are currently working with, and you agree not to do that for a year. That is a non-compete. They don't want you to compete with their business or their clientele. Typically, the way that a non-compete would look on paper is, let's say you work for a hair salon and you have to sign a non-compete, and the non-compete says that you agree not to work for another competing hair salon that is located within a 5-mile radius from your current employer, and you agree not to do so for a year. That's what a non-compete looks like. A non-compete tries to restrict you from working for a competitor in a particular area and for a particular set of time. They are vastly different. A non-compete isn't necessarily trying to protect trade secrets. It's trying to protect their business from you competing on a more physical level with them. The companies are afraid, and this is why they create non-competes, they're afraid that information that you might have learned while you were working at their company, you could use to help another company. And now you might be saying to yourself, yeah, but wait a minute, isn't that a non-disclosure? Well, yes and no. And this is why people use these two terms interchangeably, and they shouldn't, because sometimes you could have a non-compete and a non-disclosure. You might be told not to provide information about their trade secrets or their processes on a non-disclosure agreement. But what if you don't disclose the trade secrets, you just disclose other things, the way that they normally run their business? So that's why certain employers will impose a non-compete as well. I know there's some nuances here, and it's kind of like wordplay, but think about it like this. Your non-disclosure agreement, it obviously can't restrict you from talking about everything, right? Because, it's not like you work in Area 51 and you're not allowed to talk about anything. And I guarantee you that there's restrictive covenants in Area 51, by the way. But anyway, they can't stop you from talking about everything. For example, if you want to talk about where you work, when you work, that's not a trade secret necessarily. So by enforcing or trying to enforce a non-compete agreement, they're trying to catch all of those other things that aren't necessarily covered under a non-disclosure agreement. They don't want you to compete with their business for a set period of time. It also could be because an employer doesn't want you to compete because you might take some of their clientele with them. There is something called a non-solicitation agreement, which is another form of restrictive covenant. We'll talk about that in another video because I really want to just focus on the difference between a non-disclosure and a non-compete. But hopefully you can see there is a distinction. A non-compete seeks to prevent you from working with a competitor for a set period of time and in a certain geographical region. While a non-disclosure agreement doesn't care where you work after you leave your current employer, it simply says you're not allowed to disclose certain information. Now, are they good? Are they bad? Are restrictive covenants inherently evil? No. And it's the court system, the legal system, that makes sure that a company or an employer or an individual is not overstepping the bounds of what is legally acceptable. So in other words, if you are an employer, you can't get away with trying to have an employee sign a non-compete agreement that prevents them from working in, let's say again, you're in the hair industry for a hair salon for the next 10 years. I mean, you can't do that. That's against, the law, basically, because you're taking away someone's livelihood. So you can't do that. And the courts look at these restrictive covenants on a case-by-case basis to decide whether or not you've gone too far, if you will. So that's how the legal system comes into play, because it's a checks and balances system. It makes sure that what you are signing is fair. At the same time, though, I just have to warn you, whether you are an employer or an employee, what you are given and what you give, you have to read. You have to understand what it is that you are either agreeing to or asking the employee to agree to. You don't want to be in a situation, and I've actually seen this before, where a company thinks they're giving a non-disclosure agreement, but they're actually giving a non-compete. And the two documents are different. Likewise, you could be an employee and you could think you're signing a non-disclosure agreement, but in essence, you're signing a non-compete. So it's really important that you have an understanding of what it is you're signing, because some agreements are very confusing. They kind of mix the non-disclosure, non-compete, non-solicitation all into one paragraph, and it can be very tricky to pick out what it is you're signing. So if you're an employer and you have one of these agreements that maybe you inherited from a predecessor or you found online, you might want to have a lawyer look at that to see, is there a better way to say it? Is there a better way to be more clear about what you're trying to do? And as an employee, if you get an agreement from an employer or a company that wants to hire you as an independent contractor and you don't understand it, go hire a lawyer to have them review it for you. I don't think that anyone's trying to deceive or trick anybody with a non-compete or a non-disclosure. It's really a matter of, are you, conveying what you're trying to accomplish in a clear and understandable manner? In legal contracts and legalese, it's so outdated. We don't live in the 1700s anymore. And using words where to, for, here, thereafter, you get bogged down in this legal terminology that has really very little relevance to the modern world. So, let's try to cut through that and create documents that are clear, that use plain language, so that you as an employer know what you're asking the employee to give up, and you as the employee know what you're agreeing to give up. So I went off on a tangent, a little rant about legalese and contracts, but to sum up today's video, the difference between a non-disclosure and a non-compete is that a non-disclosure seeks to prevent you from sharing with anyone else trade secrets or other information that company deems proprietary or something that they want to protect. Whereas a non-compete tries to prevent you from working for a competitor or within the industry for a set period of time and for a set geographical region. All right, I hope that makes sense. I know I kind of went off on a tangent there a bit, but hopefully I was clear enough with the distinctions between the two. We're going to continue with some additional videos talking about restrictive covenants because A, they're fascinating, B, everybody at one point or another is going to encounter them, and I really want people to have a better understanding of what it is that you're agreeing to or giving to a potential employee or independent contractor. All right, that's going to do it for today's video. If you have any comments about this topic or you'd like other topics discussed, please leave some comments in the comment section below, and I'll be sure to look at them and do my best to get other videos that might be of interest to you up in the very near future. Thanks for joining me. I'll see you next time.
I've been trying to find my way.